The following discussion and materials are to be used for informational and training purposes only. They are not intended to supplant the requirements of the Assessor's Reference Library, the Colorado Constitution and statutes, and relevant court case law. You should consult and rely upon appropriate legal authority. Welcome to the Colorado Division of Property Taxation's video library. We hope you gain useful information and enjoy our presentation of this course.
Hello. The following presentation is intended to give an overview of many of the key concepts with the Senior Citizens and Disabled Veterans Exemption Program. I will discuss concepts such as the program overview, program eligibility, application process, how the assessors administer the program, other government agencies involved, and some frequently asked questions concerning the program. The exemption program began for seniors in 2001 after a ballot referendum. Within a few years, disabled veterans and the surviving spouses of both senior citizens and disabled veterans were able to apply to the program. Currently, the program exempts 50% of the first $200,000 worth of actual value of the eligible applicant's primary residence. However, this can change each year by the legislature and can be lowered to a 0% reduction in bad budget years. County and local governments do not lose any funding or revenue due to this program. Instead, the state treasurer reimburses the taxes exempted for qualified applicants from the general fund. Each participant in the program has a different eligibility requirement. For senior citizens, seniors have to reach all their qualifications as of January 1st in the year that they're applying. They must be 65 years of age. They must have owned their home for the previous 10 years as their primary residence, and they must have occupied the home for the previous 10 years as their primary residence. Now, they can also share these qualifications with their spouse, such as, one may have the age, one may have the ownership or occupancy, but as long as between the senior and their spouse, they're able to meet these qualifications, they can apply for the program. Disabled veterans have a slightly different qualification. And you'll see on the screen here, this second line is extremely important. First, they have to have been discharged from the military under honorable conditions. This second point, I've taken this directly from the statutory language. And the reason I tell you this is that this has changed in the last couple of years and has been a bit of contention with some lobbyist groups. So if your applications or what you have on your website doesn't say something similar to us, you should consult your statutory guidelines or contact the DPT in order to discuss this, because this can become a problem since this has changed. The applicant must have received a service-connected disability that has been rated by the Federal Department of Veterans Affairs as a 100% disability through disability retirement benefits. And the applicant must have resided at their home as their primary residence since January 1st in the year in which they're applying. Surviving spouses of senior citizens can apply if their spouse passes away and they don't meet the requirements fully on their own. Now, the applicant must have been married to a senior who qualified or would have qualified for the program, but has since passed away. The surviving spouse applicant may not have remarried. Applicants or their deceased spouse must have owned the home for the previous 10 years. Again, much like with our living applicant senior, this can be a shared 10-year, like one of them could have had the 10-year ownership, the other occupancy or the age range. And the applicant must occupy the home as their primary residence and must have done so with the deceased spouse. Eligibility for surviving spouses of disabled veterans, again, a little different. They must have been legally married on January 1st to a previously qualified disabled veteran who passed away prior to January 1st, and they must not have remarried. And they must occupy the property as their primary residence, and they must have occupied it with the veteran that has passed away. This is very important. The veteran must have had qualification and been in the program. The Colorado Department of Veterans and Military Affairs is unable to qualify a veteran once they pass away. The law requires that the surviving spouse must apply, as the spouse of someone who was previously qualified. Once someone passes away, there's no legal way to qualify them, so we cannot go back. With seniors, as I mentioned, they would have had to have met the qualifications, but for veterans, they had to have actually had the qualification. If you have any questions concerning this, please contact the DPT. It's very rare we can't help the surviving spouse of a vet, but the law is very specific on this process. I'm going to now discuss essentially a cycle or a year and the senior exemption program and how the assessor's office would process it. This process will go through notification the whole way through reimbursement. First, the taxpayer must receive notification of the exemption in order to apply. Statutory law requires that the treasurer's office sends a notice as soon as possible after January 1st, normally with the tax bill, of the senior exemption program. If the assessor is sending a separate NOV from the tax bill, they must send notice of both the senior exemption and the disabled veterans exemption. However, the law does allow us, and encourages, in fact, that county officials coordinate with both the treasurer and assessor to send a notice that will cover both of their statutory requirements early in the year. Essentially, with the tax bill, if you can work together with the assessor and the treasurer's office, you can send out a single notification that will take care of you for that tax year. There are 4 different applications for the program. There's the senior short form. This covers most senior exemptions and is the bulk of what you'll deal with in the assessor's office. This is for senior citizens that own their home in their own name and do not have any odd conditions, such as the property being in a trust, one of the seniors living in a home, or anything of that nature. The senior long form is used for exceptions to eligibility rules. Aside from the trust that I mentioned, or something such as a senior in a retirement facility, that they would return to their home but they can't because of health issues. This can also help someone if their home has been destroyed, or if an eminent domain proceeding has happened. There's a few other unique situations with mobile homes from before 1978 that also can be taken care of with the senior long form. Again, these are a very rare circumstance involving the senior long form and the mobile homes. If that arises, please contact the DPT for further guidance, but most likely any of you that are working with mobile homes already probably have an idea how this works out. For disabled veterans, there's only one form. This form, it basically asks just simple information about the veterans, and it goes to the Colorado Department of Veterans and Military Affairs in order to give them their disability qualification, and then the application is furthered to the assessor's office for qualification for residency. For the disabled veteran surviving spouse, there is also just a single form. It's about a half a page, and this is turned into the assessor's office. The surviving spouse of the vet fills it up. It simply asks essentially the address, the surviving spouse, and the previously qualified veteran's information. On this slide, you'll see a matrix that shows us each of the forms, what agency receives them, and 2 dates. This is important to remember because the Senior and Veterans Program has both timely filing dates as well as a late filing date. The major difference here being that timely filed dates give the applicant appeal rights if their application is denied at the assessor's office level. Late filing dates are 30 days after the timely filed date, and although for many of these they must be accepted by the assessor, the taxpayer will lose their appeal rights. And if they are denied, they just have to try again the next year. There is one caveat here. The Disabled Veteran Program, the late filing date is for the Colorado Department of Military and Veterans Affairs, and is at their sole discretion whether they'll accept late filers. This is not something that they do as a matter of habit. It's very rare. And we at the DPT urge most veterans to make sure they file by the timely date in order to keep the possibility of applying that year on the table. And we recommend that most assessors' offices urge your veterans to go and get that taken care of by July 1st as well. And you can see here, this first column gives us our timely file dates. For seniors, it's July 15th for both the seniors and their surviving spouses. For the disabled veterans, they have a due date, timely filed due date of July 1st. For their surviving spouses, it is July 1st as well, but you'll notice it goes to the county assessors. These applications do not go to the Department of Veterans and Military Affairs. As we've discussed, the veteran has already been qualified. This is simply a matter of transferring the exemption over to the surviving spouse at the assessor's office for an account that's already been qualified. So this surviving spouse disabled veteran form goes to the county assessor's office. These things, if they go to the Department of Military and Veterans Affairs, can get lost. So it's very good if we have a surviving spouse of a vet, we want to make sure that we're getting them to the correct place. And they also have that late filing date. That is going to function just like these August ones for the seniors, where the assessor's office should and statutorily is required to take these until August 1st. Now we have to process these applications so that we can get our reports ready for the DPT in the fall. A couple things to keep in mind here. Applications are time sensitive. The deadlines on our last slide showed us that someone can lose their exemption if they're not on time. So these applications, when they come into your office via the mail, should be immediately date stamped, and please save the envelope if it's a postmark date. We work with postmark dates. We don't work with the day that comes to your office. So if a form comes to you July 17th as opposed to July 15th, but it's postmarked July 13th, that is a timely filed application. Applications should be reviewed and processed as soon as possible. This is in case there's any problems. Many of the folks in our program may make typos, forget pieces of information, and although we are not required at the assessor's office to reach out to these folks and make changes, is a matter of customer service and just keeping good public relations. Many counties will reach out and try to make sure the applications are complete by the end of the application period in order to ensure that these seniors and the vets can continue getting these exemptions. Big no-no, applications for previous years are prohibited by law. We cannot accept things for other years. Once it's done, and applications must be completed and signed. All of the information we request has to be on there. Full social security numbers, that's a big one. Make sure they didn't leave a digit out or only give you the last four. Some folks like to do that. If we don't find that out until later in the process, they will get removed. They have to sign it. The attestation at the end we give them declares that the information they give us under charges of perjury is true. This is one of the ways that we can remove exemptions by law if we have to. So we have to have that signature in there as well to make sure that everyone's on the same page and we're doing everything legally compliant. Now, the assessor's office does a couple of things with these applications. First, they're going to verify the age for the seniors. Although not required, many offices will get a copy of the driver's license or some type of identification card to keep in their file, so they have that. The assessor's office also verifies the residency for both senior citizens and veterans. The Colorado Department of Veterans Affairs handles the disability ratings for the veterans exemptions, and then they'll forward the applications to the assessor's office for the residency requirements. Now, no party may accept applications past the statutory deadlines. And if possible, we recommend you remove the applications from your website outside of the application window. The Division of Property Taxation does this every year. The day of, we take them down. We don't put them back up till January 1st. We recommend, if at all possible, that you do the same. I know many counties do link back to our website, so you may not be even aware, but your applications may be being taken down yearly. Also, we do possibly make new ones. Sometimes there are legislative changes or little tweaks that we make to the forms. Older forms, although still useful, can have problematic changes, such as I mentioned on the veterans qualifications, so you want to make sure you have the most up-to-date information on your website as possible. With all these applications we got in, some of them are going to be bad. So we have to deal with the denials and revocations. The most common denials that you're going to get at the assessor's office is an applicant or the applicant and their spouse applied for more than one exemption in your county, what we call the double dipper. You also get a lot of ones with people's age, not being 65 yet as of the start of the year, and you'll find problems with ownership or occupancy, incomplete or unsigned applications. It's very key with the age ownership requirements that if you do deny it, you deny it, follow the denial procedures I'll discuss in a moment, and then get rid of the application. Please do not keep the application on hold for future years. The application is set up to have the taxpayer sign and verify and essentially swear under oath for that attestation that they meet the requirements at the time they're turning it in. If an assessor's office accepts this form and it is incorrect, you're essentially taking part in this person giving you bad information and signing off under perjury that they're giving you good information. We should try to not encourage this. And just for simple record keeping, we've had problems in the past where applications that were kept for the next year disappeared, angry taxpayers, information was lost. It's just very important to keep things within the statutory periods for organization as well as legal compliance. We also have revocations. The previous slide we discussed denials, which is a new application coming in, but a revocation is going to be the removal of an exemption once someone has lost their eligibility requirements. Most commonly, this is going to be eligibility, such as your ownership or occupancy, but please do keep in mind there are some things such as our surviving spouse forms, someone passing away, that ownership changing, eminent domain, destruction of a property, or the property going into a trust, all ownership changes that through the use of a long form, the senior can keep their exemption. As you can imagine, just like anything else in our lives, once we deny a taxpayer, we have to go through an appeals period to give them their due process. So, with our revocations, notice is technically not required under law, but the DPT highly recommends it. It's just a good idea. It will keep you good PR, it will keep everything on the same page, and you won't have a slew of taxpayers coming into your office screaming at you when they get their tax bills, and there's nothing they can do to alleviate the situation. And if you were wrong in the revocation, well, you've got more problems because it's past the reporting deadlines to get reimbursed. So you want to keep this taken care of when you can. Now, denials, we do have to send out a notice. They must be provided and dated no later than August 1st. And the appeal period for this is going to go from August 1st to September 1st. The CBOE will hear any appeals, and the CBOE decision is final at the county level for any denials. And on rare occasion, you will have a senior that wants to waive the exemption that they already have in place. Get something in writing. There's no legal proper mechanism to handle this. However, you want to make sure that you're safe in this situation. The Division of Property Taxation has produced a template that you can use, or you can create something else. Essentially, you just want to have a signed letter or form from the taxpayer saying that they want to give up this benefit and that they understand that if they're going to get the benefit again, they'll have to start over with a new application and that they can't just call you and start it up. This will keep you protected, let the taxpayer know what's going on, and make sure everyone's on the same page in the process. Now that you have your denials done and you're applying your exemptions to your properties, you want to take special care with agricultural land, mixed use, and contiguous property. For land that includes mixed use or agricultural lands, the exemption may only be applied to the residential portion of the account that is used by the applicant as part of their primary residence. Contiguous properties that are used as part of the residential primary residence may also be eligible. The key thing to keep in mind here is that in either case, if you're combining bits of parcels or taking bits of land from a mixed use like that, the exemption may never exceed the threshold, which, as we discussed, is currently 50% of the first $200,000. Very big issue with this program is confidentiality and data retention. The applications and the information they contain are confidential. We've got people's addresses, names, social security numbers, their signatures, pretty much everything about them. The applications should be kept in a secured or locked cabinet. If you're keeping digital copies, if you scan them in for posterity, the drives should be secured drives that only a few folks, the important people, have access to. It shouldn't be on your main drives. The DPT will often ask for copies of these files, not even just the first year, sometimes several years down the road. So you have to keep these as long as the exemption's in place, and you must keep them without redactions. We will often use the social security numbers as part of what we do in our review. And it is illegal to provide this information to a few folks, either outside the assessor's office, treasurer's office, the Division of Property Taxation, or state auditors. It is also illegal to provide lists of applicants, occupants, qualifying recipients in any way that could be used to create a mailing list of either recipients or applicants. Applications for existing exemptions should be retained indefinitely. Basically, as long as the exemption's in place, keep it on hand. Once the exemption is removed, you would need to keep the applications for 6 plus the current year for data retention laws. After that, it just needs to be destroyed in any manner that's suitable for destroying paper that has PII on it or personally identifying information. All of this processing and all these applications lead to 3 big statutorily required reports. At least for me, this is one of the more important parts of the program because this is what I work with a lot and why I'm talking to you today. And it also is how you folks get your reimbursement in the counties and how we get that money back to you. So we have 3 dates. September 10th is the first upload for the year. This is a dead drop line. This is not a suggested time. This is the cutoff period for it. If you think that you may have errors or problems that you need help, you should probably start before then because the deadline's September 10th for the completed files, not to begin the process. Now, this is the first round of filing. This is very important. The Division of Property Taxation, we use this to check for our double exemptions. We use this to check for out-of-state non-resident filers. We use this to clean up typographical errors or any type of errors. We often get dozens of seniors a year who will write down the wrong social security number on their application. We have to ferret these folks out, find the correct social security number for each people. The less errors in your data that you send to us, the less we have to do this, the less we have to bother some of these folks. And it's just general good customer service for us in the county, the better these files are. We also use these for our death record check that we do in the spring. So it's very important that everything is here. More importantly, this is the only file that you can put new applicants in. This is the time to show us who you're going to be requesting reimbursement for. After this file is sent in, you'll no longer be able to add applicants to the program. Now, the next is going to be January 10th. This is also the county assessor that sends this. This is a very simple check with the DPT. All we really do is look at it, make sure the values are good, and then anything we would have sent from our September review that were bad exemptions that weren't eligible, they should be removed and no new ones are added in. And then our final report comes from the treasurer's office, although I know many county assessors supply this for the treasurer, and this is essentially your reimbursement request. This has to be perfect. There should be no changes from the January 10th report. Occasionally there will be a removal or so, but it should be essentially an identical file. This is what we will use to verify your reimbursement request and send to the treasurer's office so that they can cut the check and send it back to you. The reports will go into a database from our website that we could refer to as the county portal. The county portal was launched in 2019. It allows for the uploading of senior and veterans data as well as abstract and certification data, and down the road it's going to carry some more programs. The senior and veterans exemption was one of the big starting ones for this program, and it's really kind of a wonderful tool. It's increased efficiency. Anyone who has worked with the program knows the old process. It would go to a Dropbox. There would be a manual review by a DPC staff member, mainly me, and then we would contact you if there was any data formatting errors. This system gives you immediate feedback, so you don't have to wait a day while we run reports. It will let you know anything that you need to fix before it's finally set, and then you have a variety of reports that you can pull about your information for your own use. There's quite a few tools in there. We're adding them all the time. It is the standard, but we'll be using going forward with this. Anybody in your county that's working with this should have a login. Again, you don't want everybody in the office to have it, but just anyone that's dealing with the secure data should have their own. And please, no sharing of logins. Once someone leaves the county for security purposes, we deactivate their account. So if you've got an office and you've got 4 or 5, techs working on the same thing, and they're all logging into the same account, everybody's going to lose their account at once, and then whenever you go to put their information in, you're going to have to go through the whole process of essentially starting over with your account. So please, one person, one account, it keeps us safe and secure that way. At that point, once that gets loaded up to that county portal and the data files are fine, the DPT will review and begin the reimbursement process. As I mentioned during the reporting slide, we do a variety of checks to ensure that everyone in the program is eligible to receive these funds. And this includes an expansion of double exemptions, wherein your county would check for within the county, we check across the entire state. We send notices to any of our denials and let them know how to appeal. There is a very limited basis for many of our appeals, and after this, there's no further appeal beyond the property tax administrator under the DPT umbrella. And we will notify the assessor of any denials at the end of this process. Finally, when we get to that third round of treasurer filings and your reimbursement, this is where the game basically ends and we get our prize. The county treasurer files that third report. We evaluate it just to make sure the numbers are good, nothing has changed. This serves as your official request. After the reviews are complete, we have that final upload from the treasurer. We do a quick review of that to make sure that there's no value changes, no applicant changes, and this will serve as your official reimbursement request from the county. Once that's all verified, I send that over to the state treasurer's office. The county treasurer will then send an accompanying request letter, and from that point, the state treasurer takes over Gets you folks a check within a couple of weeks, and that tax year is over. By that time, the assessor's office is already partway through the next year's cycle, and we just keep doing it. Finally, I have a few frequently asked questions involving this program. This is stuff we get a lot of calls on, people email us about regularly, that we kind of want to help empower you folks to be able to answer these questions on your own because, well, it's just frustrating to not know some of these things that come up rather often. So I've got a couple of pages of these, just kind of answer them real quick for you. Hopefully that will get you a leg up on the next season. Can I make changes or additions after filing? Well, yes and no. Changes to accounts, such as parcel number changes from a split or a combination, are understandable and accepted. If you can minimize those after you send your files, we really appreciate it, as it kind of slow down our verification processes, but it happens. However, you cannot add anything after the first upload. This first upload is how we qualify people, and once it's over for the year. When should we remove deceased applicants? We do everything in this program, for eligibility requirements at least, as of January 1st. So if someone is alive January 1st of 2019 and they pass away during that course of that year, we keep them on there and we keep their exemption until the next year. Now, if they passed away in 19, as of January 1st, 2020, they would be removed, barring a surviving spouse application. The deceased list from the DPT that you receive will come to you in the year that they should be removed, in the spring, and with proper instructions on how and when to remove them. But as a general rule, when someone dies, you take them off next year. And that would be the case with almost any status change. For the year they qualify as of January 1st, we keep them, and then we remove them when they no longer qualify as of January 1st. Another unique situation that we come across, seniors will often quitclaim a property as they're getting older to their children to try to avoid an estate tax or some other type of end-of-life financial situation. And then they'll call us, freaking out, asking if they can keep their exemption. Well, if they have it ownership on January 1st and they have the exemption, they're fine. The next January 1st, if their kids have the ownership, then they lose the exemption and they would have to start over again, the full 10 years and everything. However, if they transfer it back and forth in the same year, they're still eligible as long as they have ownership on both of those January ones. So there can be a disruption in ownership during a calendar year as long as it's in the appropriate place for ownership and occupancy as of the next January 1st. However, when advising a senior on this, you can explain this information to them, but please do not get too far into your advice. Some of this is something that should be handled by their financial planners or their attorneys. You don't want to be giving legal advice if you're not an attorney, so be very careful with this information and how you give this to taxpayers. I'm a senior citizen and a disabled veteran. Can I get both? No, you cannot. Which should I apply for? That we do have an answer. The Senior Citizen Program has been shut down a few times. There has not been enough money in the budget. We do not forecast that this year, but it happens. And in those years, the Disabled Veterans Program is always funded. If you have a taxpayer that qualifies for both programs, we urge you to have them fill out the Disabled Veterans application. And remember, getting both is just like a double exemption in any program. You want to stop them from doing that. Now, as I mentioned, we send out notifications to our folks that we deny. In the past, once we send that information out to county assessor's office, some have questioned whether or not we have sent notification out to the taxpayers. The answer is yes, we have. If we've told you to remove something, the taxpayer knows, possibly in duplicate or triplicate at that point, depending on what type of letter they got. However, they have been noticed. Once we denied them and their appeal period is over, please do not send out another notification to them. This can make them think that there's another round of appeals possible and create a whole mess and open a can of worms that nobody's office wants. We take care of this. We follow our statutory guidelines. If you have any questions about whether or not they were notified or anything, please give us a call first, but do not send out notifications about the DPT's denials on your own. A few offices have done this and it caused them a lot of headaches just due to the customer service calls they got, and there was really nothing we could do to help them because it was their mailing, and it was just kind of a mess. So we let them know, and you won't have to let them know about our denials, just your own. Can I transfer property XYZ to ABC? No, you cannot transfer. Veterans may move if they are resident as of January 1st. Make sure that you remove it from the old property so it doesn't appear as a double exemption. But senior citizens are not able to move. They have to have the 10-year residency and occupancy requirement. And it doesn't matter if it's across the street. It doesn't matter if it's one unit down in the condo, one apartment over. That if it's a change in the parcel number and the property number, their 10 years starts over again. Will it be funded? We don't often know until we find out ourselves. We have indications at times, but we can't really tell you that, at least until we get information from our legislators and they sign off on the long bill and give us a budget for the year. When that happens, and this is usually late spring, we will send something out in the bulletin. So if you're worried and you're getting a lot of taxpayer calls that are all stressed out about whether or not they're going to get their exemption, just keep an eye on that bulletin. We'll let you know as soon as we do. And finally, I was eligible last year, but again, we can never go back to another year. This is illegal. The county cannot be reimbursed for it. The property will not be paid for. There's no appeal, there's no excuse, and no agency can help them with this. This is kind of a line in the sand thing in the law, and please feel empowered to tell them this. We've had some issues in the past with some customer service folks at some counties just pushing this information, saying maybe the state can help you. I know it's hard to say no sometimes, and you might want to get your assessor or your supervisor on the call if you're having problems with this, but to send them to one or two other agencies gives them a false hope, often leads them to become very angry, and they'll call back to you anyways to try to discuss it with you again. This is something we have to be firm about and try to come across with them. Please feel empowered to do so. This is, a very simple legal thing that we can make sure that they understand, explain it to them, but we don't want to send them all over the place on this one. It's very important that we kind of keep consistent and we don't keep these seniors on the phone 3, 4, 5, 6 phone calls for the same exact answer that can't change. And of course, there's all kinds of other odd contingencies and crazy things that happen with this program. So please, at any time you need help, give us a call. Our mainline number, as you can see here, and most of you that are watching this video probably know who you want to call anyways. We're always available to help, and we're always happy to talk to you. Thank you. I hope this presentation was informative, and have a good day.
Thank you for watching our presentation. We hope this format will benefit you in your work for ad valorem taxation. If you would like to provide any feedback or have any questions about the course, please contact the Colorado Division of Property Taxation.